As a gun owner of many different types and a 20-year military veteran, I have some expertise in weaponry and self-defense weapons. What could you, in 15 seconds, would you define an assault weapon for me?
So
If you go past 15 seconds, I'll just interrupt you.
no, so I'll go shorter than that, because I honestly, I do think if Congress wishes to take that up, I think Congress would have to do the work, but we would be there to provide technical assistance. Unlike you, I'm not a firearms expert to the same extent as you may be, but we have people at ATF who can talk about velocity of firearms, what damage different kinds of firearms cause, so that whatever determination you chose to make would be an informed one.
Connecticut District Court judge upholds Connecticut's assault weapons ban and large capacity magazine ruling. What a shock. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like my channel, like my content, and what I do here, you can support me with the link in the description box. Everything is appreciated. Let's talk about this. Now, this is articles written August 18th, actually today, the day of this video. But a district court judge has ruled that Connecticut's basically assault weapons ban and capacity magazine bans are both not protected by the Second Amendment. Now, if you remember, a little while back, I did another video on another district court judge, or another judge, who basically ruled the same thing. It's for, I believe it's Illinois. I'll pull it up. And he basically said that the assault weapon ban was not, well, the ban is not against the Constitution, is basically what he was saying. But you're going to find out, if you read his briefings, you're going to find out that the same language is being used here, which is of no surprise. But I'm going to jump in. Okay, judge upholds Connecticut ban on semi-automatic firearms. August 3rd, 2023, Judge Janet Bond Arterton of the United States District Court for the District of Connecticut ruled on whether the recent Connecticut law banning the possession of common semi-automatic rifles and pistols under the appellation of assault weapons and of standard capacity magazines which hold more than 10 rounds. Judge Arterton ruled the law is not prohibited by the Second Amendment, shall not be infringed. But she does not see it as an infringement, because she claims assault weapons and magazines over 10 rounds are not arms protected by the Second Amendment. Why not? Magazines that hold more than 10 rounds are referred to as large capacity magazines, or LCMs, by the court from NA, National Association of Gun Rights versus Lamont. For the reasons discussed below, the court denies plaintiffs' motions for a preliminary injunction because they have failed to meet their burden to demonstrate a likelihood of success on their claim that the challenge statute unconstitutionally burdened their Second Amendment right to keep and bear arms. Plaintiffs' proposed ownership of assault weapons and LCMs is not protected by the Second Amendment because they have not demonstrated that the specific assault weapons and LCMs in the challenge statutes are commonly sought out, purchased, and used for self-defense, even though the AR-15 is the most popular semi-automatic rifle in the country. Once again, you have to question these judges, but we do see a larger problem here, and I'll discuss that later. Although this failure alone would have been fatal to plaintiff's claim, defendants have submitted a persuasive evidence that assault weapons and LCMs are more often sought out for their militaristic characteristics than for self-defense. That these characteristics make the weapons disproportionately dangerous to the public based on their increasing capacity for lethality, and that assault weapons and LCMs are more often used in crimes and mass shootings than in self-defense, which is a bunch of crap. Mini 14s, M1As, Grands, you could go on and on of semi-automatic weapons, that some of which fire a much heavier caliber than an AR-15. So this is a bunch of crap. But this is not about logic. This is about something I'm going to discuss after. Okay, I got it on my brain here, but let me get through this. Judge Arterton used this claim to place the burden of proof on those opposing the firearms ban. Her argument rests on two interpretations of Heller, McDonald, and Bruin, and the dismissal of Caetano as irrelevant. Heller sets up the standard protected arms are those which are in common use for lawful purposes. From Judge Arterton's page 18, Heller characterized Miller as standing for the proposition that the Second Amendment extends only to certain types of weapons. At 622-23, weapons used in defense of person and home are constitutionally protected, but weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barrel shotguns, are not. And she gives another reference. The historical tradition of prohibiting the carry of dangerous and unusual weapons, as discussed in the 18th and 19th century treaties, Heller held supported Miller's restriction on the scope of the Second Amendment, which Heller described as an important limitation on the right. And this is, of course, the author. Heller did not limit the right to keep and bear arms more than Miller. Instead, Heller showed the arms protected were all arms in common use for lawful purposes, not just those arms which were useful in the military. Judge Arterton lays down the Connecticut government's explanation of what common use for lawful purposes means by their definition. Well, now we're asking the state of Connecticut to define what common use means as far as firearms go. Can you not see where that's going? They claim the test was changed by the Bruin decision to mean commonly used and documented as used for self-defense, not for other lawful purposes. They claim the documented uses for self-defense must be more common than criminal uses. And this is from their brief in 27. Broadly, defendants view the three different phrases as ultimately getting at whether the firearms at issue are suitable and used for self-defense or for some other purposes, lawful or unlawful, unprotected by the Second Amendment. Defense maintains that after Bruin, plaintiffs must show not only that the weapons and accoutrements are commonly owned, but they are commonly possessed and used for self-defense based on Bruin's repeated use of the phrase common use for self-defense. Well, let's go back to the LA riots of, if you remember, was it 90s? Okay. What were those Korean grocers using as they sat on top of their stores protecting their stores? So-called assault weapons. This judge there's, like I said, I'm going to talk about it later. Judge Arterton agrees with the Connecticut's government's interpretation of common use from page 35 because she's a liberal and she goes right along with the game. Thus, the court finds that the purpose of the dangerous and unusual exception to the Second Amendment is to determine whether the firearm's character is such that it is commonly used and typically possessed for self-defense or instead for the purpose of causing unlawful or excessive harm or fatalities. Well, that's bizarre. So they're saying because criminals use it, it's more a criminal thing than a law-abiding citizen thing. That's a strange language, but this interpretation of the test is also consistent with the interplay between common use, typical possession, and dangerous and unusual. A weapon must be both possessed for the purpose of and actually used for self-defense in order to fall within the Second Amendment's protection. Well, here's the thing. Law-abiding citizens who own AR-15s just don't go out and create situations where they have to use it lawfully. We don't do that. Criminals actually create situations where they use these kinds of things for unlawful purposes. So our argument is kind of stupid. But, meaning that if it is either unusual for it to be possessed for self-defense, or if it is used in a way that makes it particularly dangerous, the weapon does not fall within the Second Amendment purview. Whew, okay. To prevail on this question, plaintiffs must show that carrying both a firearm defined as an assault weapon and that possessing and using an LCM in conjunction with an assault weapon are part of keeping and bearing arms. If plaintiffs establish each of these elements, the burden shifts to defendants to justify their regulation based on Bruin's requirement for establishing relevant similarity to history and tradition. And then she goes on to the magazines. On page 40, the judge concludes LCMs are arms as defined in Bruin and Heller, but then claims they are not protected because they are not commonly used in self-defense. Yeah, she actually said that. The court concludes that LCMs are arms for the purposes of the Second Amendment, as defined in Bruin and Heller. Plaintiffs have met their burden in this part of the analysis. In the absence of persuasive evidence that the assault weapons or LCMs listed in the statutes are commonly used or are particularly suitable for self-defense, plaintiffs have failed to carry the burden. Now, it goes on and on. I'll leave it in the description box so you can read it. But, like I said, it's not so much that she did, this district court judge did this because we expect this. I expect it. Okay, let me be clear. I'm not speaking for everyone. I expected this. I expected them to just shoot this down, especially in Connecticut. Are you kidding me? But the language that she is using, if you go back, like I said, I did a video about another judge who basically did the same thing. I believe it's Illinois' assault weapons ban, and his language is pretty much the same as hers, which leads me to the speculation that there's a concerted effort among the powers that be to keep these cases in court for as long as possible. Because what we need ultimately is one of these cases to get to the Supreme Court to set the precedent. This is just my thought and my speculation. I believe that these things are being deliberately slow walked and being basically hampered at every turn in the hopes that the Supreme Court can be flipped, like remove the conservatives, and get more liberal, well, the modern day term liberal bodies into the seats, so that this becomes mute. And God help us if that ever happens. If the Supreme Court ever said that assault weapons bans are legitimate, we are in trouble up to our ears. But this is what I expected right from the beginning. Okay, I expected this. So once again, but the language she's using, I mean, she just contradicts herself and the Constitution, and that's really bloody disturbing. But what can you do? This is what we expect at this level. Hopefully, like I said, next year, maybe we'll get one of these cases in front of the Supreme Court and it will set the precedent. But hopefully, I'm hoping that the conservative judges don't go on a hunting trip and end up dying in their bed and have their body cremated a half an hour before they even have an autopsy. But that's just me. Let me know what you think. As always, you can leave your comments in the comments section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I will see you on the next one. Peace.